本日はご参加いただきましてありがとうございます。今、少しずつ、参加者の方が入ってきておりますので、もう少ししたら開始したいと思います。はい。では、本日はヒューマンライツナウのウェビナーにご参加いただきましてありがとうございます。私はヒューマンライツナウの小園と申します。ビジネス人権の、担当をしております。本日はサプライチェーンにおける強制労働の実態と輸入規制による、是正の実効性ということで、ウェビナーを開催いたします。本日はですね、同時通訳機能をご使用いただけますので、日本語スピーカーの方はですね、同時通訳チャンネルから日本語を、選択をしてください。基本的にスピーカーは英語で、お話をいたしますので、同時通訳機能をご利用いただければと思います。English speakers, please use the interpretation button and choose the English channel. ではですね、まずはじめに注意事項から、注意事項と本日の流れの方を、ご案内させていただきたいと思います。まず本日の流れとなりますが、私より、イントロダクション、主に注意事項ですね、させていただきます。続きまして、シマノのケース紹介ということで、2名、ちょっとこちらは元々の予定から追加となっておりますが、2名のスピーカーが参加いただきます。こちらではですね、私たちが発表した、報告書にも、書いております、自転車の会社ですね、シマノの、ケーススタディについてご紹介をいたします。続きまして、労働者の脆弱性と強制労働の、実態ということで、キャサリン・パーソンさんからお話をいただきます。そしてですね、輸入規制による強制労働の是正というところを、ディーンさんにお話しいただきます。最後に、報告書の提言ということで、今回私たちが発表した報告書では、日本でも、強制労働を是正するための、輸入規制というものを、法制化しようということで、報告書で提言を行っておりますので、そちらの内容についてもご紹介いたします。本日の注意事項になります。最後にですね、Q&A セッションがございます。ご質問はですね、チャットではなくて、Q&A ボックスで受け付けておりますので、こちらにお寄せください。そしてですね、もしイベント中何か接続トラブルですとか、そういった問題があった際にも Q&A ボックスに、お知らせください。また、本日のイベントは録画、録音、写真撮影、ウェブ中継は禁止しております。ご了承いただければと思います。イベントの進行を妨害される恐れがある。または本イベント登壇者、主催者の心情を傷つけたり、誹謗中傷と見受けられる行為があった場合には、ご参加者の方に途中で退席いただくことがございますので、こちらもご了承ください。また、本日のイベントは、主催者側からですね、録画をさせていただきます。こちらはですね、後日、配信を予定しておりますので、ご確認いただければと思います。はい。ではですね、こちらでイントロダクション以上となりまして、1人目の登壇者、ケイドさんにお話しいただきたいと思います。ケイドさん、よろしくお願いいたします。
Cade Mosley, the Advocacy Officer at Human Rights Now. So last October 18th, Human Rights Now released our report addressing forced labor in Japanese supply chains, a case study of Shimano, and the need for an import ban on products of forced labor. It was part of a project advocating for Japan to pass a new law banning the importation of products of forced labor. And here I'm going to talk about our report. So the report is about labor rights violations in supply chains. It starts with a case study about migrant workers from Nepal and Bangladesh, which suffered labor rights abuses in a supplier factory in Malaysia owned by Quangli Industry, or KLI, which made bicycle parts used by the Japanese-based company Shimano in the construction of their bicycles, which are then sold globally. This is a typical supply chain labor rights kind of issue where you have workers that suffer labor rights violations, but because it involves a supply chain relationship, it drags in multiple jurisdictions and actors into the violations at different levels. And there's going to be a failure at each one of these levels to stop or prevent the violations. So we have the migrant sending countries, in this case, Nepal and Bangladesh. We have the factory owners, in this case, KLI. We have the country where the factory is located and the violations occurred, Malaysia. Sometimes there are regional or industry arrangements that matter. Here, Southeast and East Asia and the light manufacturing sector. Then there's the company receiving the goods, here Shimano, the country where Shimano is headquartered and into which the products are imported, Japan, and ultimately countries and consumers buying the bicycles are financing the entire operation, and they're located around the world. So this multi-level structure is one thing that makes supply chain issues special or unique. Labor rights violations were already occurring in Malaysia, but the supply chain agreements can do two things, one bad and one good. So looking from the bottom up, from the perspective of migrant workers in Malaysia, so much money is coming in from rich developing states under these arrangements. That violations in the supplier factories are getting leveled up to industrial scales, much more than before. And authorities don't want to stop all this money coming in, so they will find ways to avoid enforcing their own labor law. But from the top-down perspective, in Japan, there's more political will to say labor rights are important, and Japan has market power and institutional capacity to put real pressure on Malaysia and Malaysian companies to stop violations linked to them, which doesn't exist to the same extent in Malaysia. So linking violations to supply chains is a double-edged sword. It makes the problem much worse, but it also brings ways to bring pressure to address the problem top down, which doesn't exist otherwise. So the basic argument of the report is the reason why you need an import ban law in Japan is because there are failures at these lower levels to address the problem by the governments of Nepal and Malaysia, by the companies KLI and Shimano, and Japan is the last level to really have a positive effect. So the report is divided into three parts. The first part covers the failures or limits of trying to address the problem through the companies. In this case, the work and negotiations with KLI and Shimano. The second part covers the reasons why the Nepalese and Malaysian governments create conditions that make workers vulnerable to forced labor, and their failures in protecting migrant workers from violations. And the third part covers how a new law in Japan, an import ban on products of forced labor, can address these labor rights violations in supply chains in light of the failures of these previous levels. There are other measures that may also help that I can talk about in the recommendations section later. So in my time left, I'm going to talk about part one of the report, the limits of trying to work with private companies to address labor rights violations in the Shimano case study. So the labor rights violations in the Shimano case started with Shimano greatly increasing its production of bicycles during the COVID-19 pandemic because there was a boom in bicycle riding. This led to agreements with suppliers like KLI to recruit a lot more workers, including 251 migrants from Nepal in 2022 on a 2-year contract. Some of the violations against the workers occurred right from the start. Most of them were required to take out high-interest loans to cover the travel travel, insurance, and other costs upfront, which is forbidden under the MOU agreement between Malaysia and Nepal and it places migrants into a never-ending debt trap that can make them vulnerable to exploitation. Their passports were confiscated, disabling them from leaving, and which is an ILO indicator of forced labor. Also, their visa status is linked to their employment. Their accommodations were poor, and their movement was also directly restricted by KLI, another ILO indicator of forced labor. So all of these things made it difficult or impossible for the workers to complain, made it difficult for them to complain and almost impossible to just leave. It's also troubling that these early violations didn't even get reported at the time before things got worse. So the real problems which started the workers' protests began in early 2023 when global demand for the bicycles collapsed, which led to a string of violations by KLI against the migrant workers to make up for the loss of demand in sales, including the start of wage deductions up to a third of their wages for things like canteen meals, savings, which were never explained or agreed on. The workers reported physical and verbal abuse because their production targets were increased to unrealistic levels they could never meet in time, and they were threatened with unpaid suspensions and threats of deportation. By June 2023, conditions had gotten so bad that the workers went outside the company to complain to a workers' NGO, which brought the complaints to the Malaysian Labor Department. A labor inspector visited KLI on June 22nd, but no action was taken afterwards, so that did nothing for them, and KLI continued the violations. Following that, 82 workers resigned as a group in June 2023. The company claimed the resignations were voluntary, but they were under clearly coercive conditions. In late June, KLI returned the workers to Nepal. They were not compensated for their early termination or for the wage theft, and no action was taken by the Malaysian Labor Department. The Nepal workers then worked with the NGO in Nepal to continue demanding compensation or alternative work, and the Nepal embassy intervened to negotiate terms for them, which started drawing public attention to the case, but KLI still ignored their demands. Our report listed violations of the Malaysian labor law, including suspensions without pay, physical and verbal abuse, excessive working hours, unconsented wage deductions, coerced resignations without notice or compensation, and a failure to report dismissals. These and other practices also met all 11 of the ILO indicators for forced labor, which I won't go over now in the interest of time. In the latter half of 2023, several people started working on the case, including the labor rights activist Andy Hall, who you'll hear from later. Aside from KLI, they were also contacting Shimano, based in Japan, which was not meaningfully responding at the time. In October 2023, our NGO, Human Rights Now, translated a letter from Andy Hall to Shimano, which finally did get their attention, and they quickly responded that they were concerned about the allegations and would conduct an investigation. Right after that, The Telegraph, a British newspaper, published an article on this case in December 2023, which brought significant public pressure, and then things started to happen. In early 2024, Shimano came up with a remediation plan that included 400,000 Nepalese rupee compensation, about 47 man Japanese yen, or 3,300 US dollars, for each complaining worker to cover recruitment fees and costs. While it was a positive outcome for the workers, there were some shortcomings with the deal. The compensation covered some costs, but not, far from all of the costs, trouble, and lost time that the workers had faced. Previous workers were also not included in the compensation deal, previous workers that had suffered the same violations. And there are allegations that at least 8 other companies linked to Shimano, all but one in Malaysia, also have poor labor conditions and labor violations, which weren't part of this deal at all. This last August, Shimano also released a group human rights policy, and it has committed to implementing forced labor prevention measures. There should be further investigation into how well this is working. Continuing to monitor the situation also gives a better chance of being effective. So that's the case study. There are a few lessons we can take from it. One is that top-down pressure works when bottom-up pressure doesn't or has limits. There was no response from KLI or Shimano until the UK article and our letter in Japanese made Shimano feel the pressure and take action after months of action by a Nepal NGO and other regional actors. Second, this is one of the first major labor rights cases that occurred after Malaysia had passed a set of labor reform laws to prevent forced labor, following a previous case by the Malaysian latex glove case in 2021. I think you'll hear about that later. That led to a U.S. import ban and reforms by the Malaysian government to prevent future bans. The point is that this case shows that having new laws and policies by themselves may not prevent future violations. You have to keep the pressure on to make sure they're enforced. A third lesson related to the first is that this case led to some workers getting some remediation because advocates could work together at all levels. The NGO in Nepal, Andy Hall, the Telegram article, Nepal's embassy, Human Rights Now in Tokyo, we all played a mutually supportive role in building pressure at different levels to KLI and Shimano and possibly to the government of Malaysia. The point is there needs to be support for civil society coordination at all of these levels of the problem for it to be effectively addressed, or else companies or governments may just ignore it. But in doing so, all actions should still always remain centered on what's best for the workers at the bottom of the supply chain. For the purposes of our report, part of the lesson is that the top-down pressure from Japan can play an especially important role because of its market power and civil society and government capacity to build pressure against companies. While we did eventually get some positive response from Shimano, a lot of the limits of the agreement and circumstances suggest that we can't always trust just negotiating with companies will lead to improvements for workers. What if we hadn't translate that letter? Or what if the Telegraph article hadn't gotten the attention it had? Would workers still be waiting for a response even now? This is why we argue that the import ban is one more tool that can help push the process from the top down to use Japan's power from the top down in a more sustainable way that governments and companies cannot easily ignore. I'll talk more at the end about when we cover in our advocacy for Japan passing a law banning the import of products of forced labor and other reforms as another measure we can use. I could cover part 2 of our report on the problems in Malaysia and Nepal, but I'll leave that for our next speaker. And you can also read our report for more information about that. That's everything I wanted to present. Thank you.
ありがとうございます。ちょっと紹介が遅れてしまったんですけれども、ケイド・モズリーさんは、ヒューマンライツの、オフィサーとして今回のレポートの執筆に、関わってくださっています。また続きまして、アンディ・フォーレさんは、人権活動家として今回レポートを、作成するにあたり、様々な情報提供などをしていただきました。レポートですね、リンクをチャットボックスにも貼るので、ぜひ皆さんダウンロードしてみてください。では、アンディ・フォーレさん、お願いします。
Okay, good morning, everybody. Thank you for the invitation to speak at this webinar. I would like to just give some reflections on the Shimano case and how it worked. Actually, in the Shimano case, I think as Cade already talked about, it was very important to have human rights now on the ground because I wasn't able to engage with the company. And so I was sending many emails and I was contacting many people, but the company didn't have any grievance mechanism, any online system, any emails. And so it was really important that Human Rights Now actually wrote a letter in Japanese and sent it to the company by personal mail, snail mail, I think we call it. And then eventually we got the response. And Shimano actually responded, I would consider very impressive, response. And they very quickly engaged, tried to collect as much information, and they remediated the victims that we had complained about. Actually, there's some victims that still haven't been remediated because it was an earlier group of workers who had been abused through high recruitment fees and other issues. But a large number of the workers that we had complained about, they were remediated. And we really saw Shimano act very admirably. And then when I was in Japan, I went to meet them in Osaka. And then last time I was in Japan, I went to meet them also in Tokyo. And when I went to meet them last time in Tokyo, they actually shared with me a draft of their human rights policy and some of the other documents that they developed in response to this case, and asked for my feedback, which was really some experience that I've never had before, to have a large multinational, conglomerate, actually asking for the feedback on the policies in the meetings. But what I wanted to talk about a little bit, just very briefly, is about how this case actually didn't need the input to bring the result around, because the company was very positive. And the import ban, because it would have took a long time. Like I was involved in 8 different WROs in Malaysia. 7 of them my petitions relating to the glove sector, and these take many years to come into play. And they really are like a last measure. If you can't get the result in another way, then you use the WROs to put pressure on the companies. But sometimes it's not necessary. And as I say, the Shimano case, it wasn't a case where we needed to escalate that. Although I think that because I was involved in the case, and because I guess my work is somewhat high profile, the company would probably, or the lawyers of the company would probably be aware that if they didn't work together with me and with my colleagues, then we would escalate it to the US CPB, and we would escalate it towards an import ban, because a lot of Shimano products are going into the US and around the world. So I think that you have to look at the situation. And so when somebody or an activist or an NGO that is involved in a campaign that is, for instance, has used the CPB mechanisms before and used them very publicly, I think companies would feel, when they get the email from me, they would look up my name and they would see linked to all this US import bans in the Malaysian glove sector and the palm oil sector in Malaysia, and they would think, okay, if we don't work with these people efficiently, we may well face a ban. So the US import ban is having a real deterrent impact on companies, and it is also contributing towards the willingness of companies to engage activists like myself. So that's really important that the US has that ban in place. And it's really important, I think, that not all Japanese companies are like Shimano. So actually I'm engaging on, I think, at least 10 or 12 cases now in Japan with many, many different companies, Yamaha, Roland, so many different companies. I've been involved with Sumitomo, with Ajinomoto, and I'm having very good engagement with these companies. Actually, they're engaging quite positively, and I think that they're delivering on promises of remediation. And again, I would say that is probably because of my reputation and the work that I've done in the past, and that the companies do fear, because they're exporting into the US, that if they don't engage in good faith and effectively, I may well escalate it to a US import ban. But I must say that some of the companies in Japan are not the same. So at the moment, I'm working on a big case in September called the Gawaguchi case. It's a really sad case of almost 300 Bangladeshi victims of modern slavery in Malaysia, in a factory called Gawaguchi, producing the plastic for Sony, Panasonic, Daikin, also Sandan Corporation. So 4 major Japanese conglomerates. And when we actually made the complaint on this case, workers are living in awful conditions. Actually, they haven't been paid, some of them, for 5, 6, 7 months. They're facing unlawful deductions. Almost everyone in the company is irregular. And when we made these complaints to the company, there's been very different responses by the Japanese companies. So actually, Daikin is a very small buyer, but they've responded very positively, very engaging. And they've responded in a way that shows they have a deep understanding of the UN Guiding Principles on Business Human Rights and the OECD guidelines. So they've responded very positively. Panasonic and Sony have not. Actually, Panasonic and Sony didn't respond at all. And it was only when we involved, for instance, organizations like the Business Human Rights Resource Center that we started to get more response from them to force them to be more transparent. But actually, at the moment, we have a really difficult situation with Sony, where their behavior, actually, they pulled out from the company, they disengaged without remediating any of the victims. And we're really entering into quite an aggressive campaign against Sony at the moment. And we've already referred this case to the US CPB. So we referred this case to the US CPB last month. because we feel very clearly that we're not getting anywhere, and it's quite an urgent situation because we have like hundreds of undocumented Bangladeshis in a very serious situation. And this is clearly systemic modern slavery and forced labor related to debt bondage, very poor accommodation, excessive working hours, unlawful deductions, non-payment of wages. And we've escalated that to CPB. It's the first case in Japan that I have escalated to the US CPB simply because of the behavior of the company. Now, I think that the important thing for the Japanese system also is that in these cases, I have referred these cases, for instance, this Gawaguchi case, because we're having a problem with the Gawaguchi case. I have referred that case, for instance, to the embassy, the Japanese embassy in Malaysia. Everyone from the ambassador, first secretary, councillor, I've got their emails and I've emailed them. And I've also emailed people on the relevant ministries in Japan to alert them to the fact.
Maybe wrap it up. Yes.
Yep. To alert them to the fact that, sorry, I saw 7 minutes. I thought it was 15 minutes. Is it less than 10 minutes, right?
Yes. Maybe a few more minutes.
No, yep, I think it's no problem. So I'm almost finished. Yeah. So I've alerted all the relevant Japanese ministries and also the embassy, and actually they're not responding at all. So in Japan, what can we do in that situation as an activist, as an organization? Because there's no forced labor law, because there's no mechanism by which we can complain to the government. Now we're moving to do an OECD complaint with the national contact point in Japan about this case. But if there was a forced labor law in place in Japan, if there was some kind of punishment within Japan for companies that were behaving like this in their supply chain, it would give activists like myself more options. So I think we have to look at, the forced labor ban now in Europe is also coming into play. That will also have a big impact, and it will add more strength to activists' toolkits. We'll have another tool. So if companies are exporting to Europe, we can threaten them with activating the EU measures, which will come into play in a few years' time. We now have obviously the US one, and I think it's obviously important that Japan and other countries can also develop these laws and these measures. It will be very positive. So yeah, I hope that's just a useful addition, just to show that, in Japan, not all companies are willing to engage in good faith with activists, with organizations like HRN. And sometimes we do need to be able to escalate, and the forced labor ban, whether it be in the US or hopefully one day in Japan, can really encourage companies to address modern slavery issues in their supply chain. So thank you very much.
ありがとうございます、アンディさん。ケイドさんとアンディさんからはですね、少し実際に日本の輸入規制を考える際にどういったケース、実際のケースに基づいてですね、どういったケースを取り扱っていくことになるのかということで、一つの事例として、シマノのケースを、紹介をさせていただき、アンディさんから少し、もう少し別のケースも紹介いただきました。一方でですね、この、日本のサプライチェーンの中での、強制労働っていうのは、このケースに限ることではなくですね、また、日本サプライチェーンに、関わるような、多くの国に、広がっているということを、次の、登壇者のキャサリンさんからご紹介をいただきたいと思います。キャサリンさんはウォークフリーで、シニアアドバイザーを、なさっております。では、キャサリンさん、どうぞお願いいたします。
Thank you so much and so much for having me this morning. My name is Catherine Parsons. I'm a senior advisor at Walk Free. My job today is to place some of the comments that have already been made today in a global context and demonstrate that these are not isolated cases of forced labor that are just happening in a couple of countries, but this really is a global phenomenon. So Walk Free is an international human rights group working to accelerate the end of all forms of modern slavery. And we use the term modern slavery really to describe two broad groups. So that essentially we divide modern slavery into forced labor and forced marriage. And today, obviously, I'll be focusing more on the forced labor side. Most people would know us through our flagship publication, which is called the Global Slavery Index. We're a very evidence-driven organisation, and we use this evidence to drive advocacy and engagement on these issues around the world. We know that almost 50 million people are living in modern slavery around the world. And of these people, approximately 28 million, so more than half, were in forced labour. That was a statistic from our Global Slavery Index that was actually from the Global Estimates of Modern Slavery that we published in 2022, along with UN organisations, the International Labour Organization and the International Organization for Migration. And it represents a 10 million increase on the last time we looked at these numbers back in 2018. So the most vulnerable people are women, children, and migrants, and they remain disproportionately affected. So more than 12 million people, more than 12 million of all the people in the world are children, and women and girls account for more than half. So, but a really important thing for Japan to think about as well is that migrant workers are 3 times more likely to be in forced labour than non-migrant workers, and that's certainly a major risk for the Japanese market. It's been 10 years since we created the Global Slavery Index. We launched the 5th edition last year, so it's a national breakdown of the extent of modern slavery, including forced labour, in 160 countries. Just to give you an idea of the scale of the research that goes into this, we conduct the largest survey of its kind, which covers 75 countries, which is a mix of face-to-face and telephone interviews with almost 110,000 respondents. Our analysis of government response draws on to almost 25,000 data points sourced from 176 countries. So it is a lot of evidence. All our methodology, all our resources are fully available on our website, and I really encourage you to explore them. So since we launched the Global Slavery Index, it's been designed to cover 3 questions. Firstly, what is the extent of modern slavery? What makes people vulnerable? And what are governments doing about it? So over the last 10 years, we've been able to gain a better understanding of where exploitation is happening, but also which countries are most at risk of purchasing goods that have been made with modern slavery. We started to look at a lot more closely recently at G20 countries, of which Japan is one. G20 countries with such large economies, they generate a great deal of demand for products, and many of which are made with forced labour. The most recent report also spotlights key themes that have emerged in the last 5 years. So this includes conflict, climate change, and also the COVID-19 pandemic. And we look at a number of key industries and how they're connected to modern slavery. So this graphic really is just to demonstrate that modern slavery takes place all over the world. Nowhere is immune. The 10 countries with the highest prevalence, that's the number of people per 1,000 living in modern slavery, are listed to the left of the map. And these countries all do share some political, social, and economic characteristics. So many are in volatile regions and have experienced conflict and political instability. Several of them have authoritarian governments or governments that perpetrate some form of state-imposed forced labour. And countries such as Saudi Arabia, the UAE and Kuwait host millions of migrant workers who, as we know, are extremely vulnerable to exploitation. The largest number of people in modern slavery are found in the 10 countries to the right of the map. And just bear in mind that these are absolute figures. So in a very sad way, it does stand to reason that countries with the largest populations are probably also going to host the largest number of people in modern slavery. But again, I urge you to look at our website for a really deep dive into what is actually driving these numbers. So we know that the pandemic, so COVID-19, that conflict and climate change, and also consumerism all increase vulnerability to forced labour. We know that the pandemic exposed and amplified inequality and instability. We know that the impact of climate change hits hardest to those who are already in vulnerable situations. Consumerism, in particular, continues to drive a demand for cheap products, which is resulting in a race to the bottom for workers' wages, or even a propensity to not pay workers at all. And finally, conflict also drives displacement and increases the risks of trafficking and slavery, particularly in countries where we're seeing ongoing war. So these, what we're calling the compounding crises, have caused a really significant disruption to employment and education. It's led to an increase in extreme poverty and forced migration, which together heighten the risk of exploitation. We know that the impacts of climate change are hitting vulnerable groups the hardest. Its effects can push people to migrate and magnify those drivers of vulnerability, such as loss of livelihoods, food insecurity, and access to resources. We know modern slavery is linked to environmentally degrading industries with high climate change impacts. And conversely, there's increasing evidence that renewable industries, which are so vital to our urgent transition to clean energy, are also reliant on forced labour. So this is could be in the mining, processing, and manufacturing of critical minerals and inputs. So, for example, risks have been identified throughout the solar energy value chain. This is everything from forced and child labour in cobalt artisanal mines in the DRC to the production of polysilicon in Xinjiang in China, which evidence shows is reliant on systemic state-imposed forced labour. So government and business action to address both climate change and modern slavery and all its intersections with conflict, with displacement, with gender and industry supply chains is really crucial. This graphic is just a quick one to show where we have analysed the risk to G20 countries in their inputs. And as you can see from the graphics at the bottom, the electronics and the garments industries are certainly showing the highest risk. There are absolutely other industries, in fact, I would argue probably most other industries that have a risk in the supply chains of products being made with forced labour as well. I wanted to just really focus a little bit on Japan, given the audience of this webinar. So according to the last Global Slavery Index, an estimated 1.1 in every 1,000 people were in modern slavery in Japan at any point in 2021. And certainly migrant workers in Japan, which, you know, there is an increasing trend towards migrant workers in Japan, is certainly probably the people most at risk. So in other words, 144,000 people experienced forced labour or forced marriage in Japan in 2021. Having said that, internally, Japan's doing pretty well. So in terms of prevalence, Japan ranks 152nd globally. Lower is good. So that's a great ranking, and also 27th within Asia and the Pacific. So I would say the major risk to Japan is in the goods that it imports. According to our statistics, in 2021, Japan imported at least $53 billion of goods at risk of modern slavery, and that's a really conservative estimate. Like many countries, the major risk categories are electronics and garments, followed by fish, solar panels, and textiles. But as I said before, all goods from all industries can potentially be made with forced labour in supply chains. Just wanted to very quickly run through a case study. Andy, I think, and Cade both mentioned the Malaysian rubber gloves. So very quickly, I just wanted to also talk about this because it's a really clear example of where an impact can come from a forced labour ban. And so this one, and Dean will speak much more to the law in the US, but this was a clear example of the impact of the US forced labour bans that come under the Tariff Act of 1930. So under the Act, the US Customs and Border Protection can issue what's called a withhold release order to prevent the import of goods made with forced labour. And around 2020, so really the beginning of the COVID pandemic, the reports of forced labour led to a withhold release order against Malaysian rubber gloves manufacturers, in particular this one, in 2021, a forced labour finding was issued. So basically at risk was about $750 million worth of glove exports into the US. So as you can see, this is a hugely motivational factor for a business to change its practices. So the process of removing the withhold release order involved extensive remedial efforts by the importer, including remediation payments to workers, improving accommodation, working conditions, and payment practices. So all these were necessary to provide evidence that the imported products were no longer being made with forced labour. Now, this hasn't solved all problems, clearly, in the Malaysian rubber glove manufacturing industry, but it is evidence that that forced labour bans can really have an impact on workers' lives. So really appreciate all the work Andy has done on these issues and for the US government for following through. So there are certain risk factors that increase the likelihood of modern slavery taking place in the first place. So some of the key risks would include whether there is a vulnerable population. So as I said, migrant workers 3 times more likely than non-migrants to be in situations of forced labour. So they're really vulnerable because the labour migration process is inherently risky. Migrant workers might not speak the local language, they might not know their workplace rights, and recruitment practices also leave migrants, or they can leave migrants in situations of debt bondage. Women and girls are also more likely to be employed in temporary, informal, or precarious positions and paid lower wages. There are also geographic risks. So please do take a look at the Global Slavery Index, which will give you a lot of information about where there are geographic risks. So, and consider risk factors in a country. So, for example, whether conflict, corruption, state-imposed forced labour is present, and whether all workers have access to protections under labour laws. Then there's high-risk work practices. So temporary workers, for example, rely on demand for labour from employers. So that leads to a power imbalance and dependency. Informal workers often don't have written contracts and are offered few protections from exploitative practices. Short-term contracting and outsourcing means the principal company might no longer even have oversight of recruitment and management. And also really important is access to grievance mechanisms. So without these, abuses can go unreported and are not remediated, leaving workers in vulnerable positions or situations of exploitation. So many of these risks emerge from governments not enforcing labour protections. So what businesses can do now is look at risky areas of your supply chain and do your due diligence. Provide remedy where you find issues and take steps to ensure that it does not happen again, it cannot happen again. So for investors looking at emerging markets, the key thing that you can do is encourage governments to enforce labour protections. Treat migrant workers the same as non-migrants, ensuring they have a minimum wage and so on. It's really important that investors do not turn their backs on companies that discover issues in their supply chains, but they need to celebrate their achievements in uncovering the problems and work with businesses to rectify them. Governments also need to introduce strong legislation, but they also need to capacity build for their companies domestically and also abroad to make sure that they can meet the high standards needed. So Japan has voluntary due diligence standards, which are a fantastic start. It's better than most countries in the world. Due diligence legislation coupled with a forced labour import ban would really set Japanese companies up for the future. And in the future, we'll hear a little bit about what's going on in the United States shortly, but also note that Canada has a forced labour import ban. It's not very well enforced at all. However, they're currently consulting on ways that they can go about strengthening that. I believe the US is placing a lot of pressure on Canada to do this. So I think watch this space because I think in future, Canada will have a much stronger ban. As Andy mentioned, the European Union has also just adopted a forced labour import ban. that will come online in about 3 years. So as these import bans and also Europe's new due diligence law begin to come online and be enforced, they will begin to impact all companies, including Japanese companies, who will be expected to show what they are doing to combat forced labour, and even to prove that their products that they are exporting have no forced labour in their supply chains. I'm just going to leave you with, this is our website. We have a lot of resources there. They're all completely free to use. We really love to hear that people are going there and actually using our information and our data. So please feel free. And at that, I will finish and hand back to Andrew. Thank you very much for having me.
ありがとうございました。キャサリンさんのお話でですね、日本がいかに、強制労働リスクの、高い商品をですね、多く、輸入しているかという、その輸入によるリスクが、分かったのではないかなと思います。さらに、その輸入先といいますか、輸入している国というのは、先ほどケーススタディで紹介した国だけではなくて、世界中にリスクが広まっているということをご紹介いただきました。で、実際にですね、じゃあこれをどのように、是正していくのかということで、輸入する側の日本としてできることの一つになるのが、強制労働に関する、産品のですね、輸入を規制する法律を作るということで、ヒューマンライツナーとしては、その輸入規制の導入を、進めようとしているわけですが、実際にすでに強制労働のですね、法規制がある、アメリカの事例をですね、ディーンさんに紹介いただこうと思います。では、ディーンさんよろしくお願いいたします。
Thank you, Andrew. I'm special advisor to Corporate Accountability Lab, which is a Chicago-based nonprofit that's focused on human rights and environmental responsibility, and in particular to help with the enforcement and improvement of U.S. laws that are dedicated to rooting out supply chain abuses. We are active in the Tariff Act Advocates Group, which is a coalition of nonprofits that are focused on the same kinds of objectives that I've just identified. We're also very active in the Coalition Against Forced Labor and Trade, which is an international coalition of groups that are dedicated to trying to find ways to deal with these problems. In addition, CAL, Corporate Accountability Lab, has been involved in filing petitions with the U.S. government, in supporting petitions for relief under Section 307 of the Tariff Act. And in fact, just recently, you may have heard about the Withhold Release Order, or WRO, that was issued with regard to frankincense from Somaliland, which is something that we were very involved in, and have also been involved in Dominican Republic sugar and other cases as well. So I want to begin with just a general discussion of Section 307 of the Tariff Act of 1930. And I don't do that with the idea that the U.S. law is perfect. It's not. We can talk about some of the problems with the U.S. law, but the United States government has decades of experience with a forced labor ban, and that experience can be useful to other countries and to human rights groups around the world that are trying to address these supply chain abuses that we're talking about today. So, as has already been discussed by Catherine, the Customs and Border Protection, CBP, in the United States can block imports into the United States by issuing a WRO when there is a, quote, reasonable indication, unquote, that the merchandise was produced with forced labor. Now, I just want everybody to think about that term for just a second. reasonable indication. That's not a standard of proof that requires the kind of like civil trial type proof that we would have in the United States. It's more of an investigation standard. In other words, when do you have enough information to reasonably believe that there is forced labor in the supply chain? And then under those circumstances, the withhold release order is the first step in the process of trying to remediate the situation. So the withhold release order can be issued, and then later there can be a finding of forced labor, which is that civil standard of probable cause, or as one judge put it, preponderance of the evidence that has to be demonstrated. But that's down the line. The first step, the withhold release order, can have enormous commercial implications and can really change the behavior of companies in the supply chain in a very dramatic way based on that initial legal step of a WRO. Civil society can participate in this process by providing Customs and Border Protection with information about labor conditions. As I mentioned, that's something that CAL often does. And then the standard or the factors that CBP looks at are based on the International Labor Organization indicators of forced labor, which are abusive vulnerability, deception, restriction of movement, isolation, physical and sexual violence, intimidation and threats, retention of identity documents, withholding of wages, debt bondage, and abusive working and living conditions, as well as excessive overtime. Even one of these factors could be used as a reasonable indication of menace of penalty and lack of voluntariness, which is the overriding standard that is applied under the WRO, under the ILO analysis. So I said even one of them, depending on the circumstances, could be a basis. Originally, Section 307 was intended to protect U.S. companies from unfairly traded imports, where the unfairness arose from forced labor conditions. So there are other U.S. laws, like the dumping law, for example, which deal with other kinds of unfairness. But this was intended to focus on forced labor. And there was a provision called the consumptive demand clause, which basically allowed the goods to come in anyway, even with forced labor in the supply chain, if there was a short supply situation in the U.S. market, if the goods were more or less being demanded and couldn't be supplied by the U.S. companies. So because of that consumptive demand clause, there was a period of time when there were no withhold release orders issued by CBP. From the year 2000 to the year 2016, there were no WROs. And as a result, in 2015 to 2016, Congress changed the law to remove the consumptive demand clause. And since then, there have been around 40 withhold release orders issued. Now, that's a little bit deceptive because the peak occurred before the Uyghur Forced Labor Prevention Act went into effect, and I'm going to talk about that in a second. We're just beginning to see Section 307 used the way it was intended in 2016 by Congress after the sort of flurry of activity under the Uyghur Forced Labor Act, Prevention Act, kind of settles down a little bit at Customs and Border Protection, and they can focus on the broader Section 307 issues. So I want to talk about the Uyghur Forced Labor Prevention Act now. And as Catherine said, and I think everybody on this panel has said, that state-imposed forced labor is different from just the forced labor that we see more generally under Section 307. And in particular, when you have situations of state-imposed forced labor, the amount of information that we can get on the ground is quite limited. The ability to remediate is quite limited, and often, if not always, in these situations, the companies that are being supplied by these state-imposed forced labor situations have no choice but to disengage if they want to avoid being involved and complicit in these practices. So that's different from Section 307, which in most instances, the goal is to for the company to stay involved and to force the remediation of the underlying circumstances and actually clean up the supply chain as opposed to exiting. So the Uyghur Forced Labor Prevention Act introduced the concept of a rebuttable presumption of forced labor. Actually, we have that also with the CATSA law, which deals with North Korea. But leaving that aside, for situations with Uyghur forced labor, there was the rebuttable presumption saying that if the goods come from the Uyghur region of China, or if the company supplying the goods is on the entities list that's maintained by an interagency task force in the United States, either one of those two instances, then the goods are presumed to be tainted by forced labor, and that presumption can be overcome with clear and convincing evidence that the goods were not produced with forced labor. I can tell you that the experience of the U.S. government to date is that there has not been a successful effort to overturn the presumption. So in most cases, well, all cases up until now, when the rebuttable presumption has been imposed, then the goods will be kept out of the U.S. market. I mentioned the entities list for a second, and I think that it's really important to understand that Customs and Border Protection does not compile the entities list. That's that interagency task force. And to date, 107 entities have been placed on that list. And it's really, really critical that we have this list because, for one thing, small and medium-sized companies often don't have as much of an ability to investigate their supply chains as the larger companies do, and they can rely on the entities list. If they're dealing with an entity on the list, they know that they have to disengage from that. Also, the entities list is an effective way under this law for the U.S. government to address labor transfer programs where the product is not originating in the Xinjiang Uyghur Autonomous Region of China, and therefore the labor is being transferred out of that region, and if the company is on the entities list, then that means that the rebuttable presumption can be applied against it. So I think that covers what I wanted to say about the UFLPA, but we can come back to that if there are questions about it. I mentioned earlier that there's some issues with Section 307. One of them is that it's been very, very difficult to get Customs and Border Protection to impose civil penalties on companies that violate Section 307, even though the law is permissive about penalties. And then I think that the circumvention issues are just beginning to really be focused on by the U.S. government. So, for example, if goods are rejected for forced labor by Customs and Border Protection, then they can go to another country and possibly gain entry into another country. And that's really not the ideal circumstance for trying to address the underlying problem. There's also issues around bifurcation of supply chains. We can talk about that. And we can talk about transshipment through third countries into the United States, and how difficult it is in many instances to gain relief from the underlying forced labor practices when the goods are traveling through a third country and then into the United States. I know that I don't have much time left, but I just want to mention a couple of common arguments that are used to not suggest that we shouldn't have this law, but to suggest that it's very, very difficult for companies to comply with it. One is that small companies often claim that they are unable to trace their supply chains. I think that the technology is going to make this argument very difficult to maintain over time, because the technology is getting better. And also, companies can make the kinds of inferences that I was talking about earlier when there is an entity that is supplying them that is on the list, or if they're unable to obtain information, then they can make an inference about what's really going on. Some claim that Section 307 is, quote, protectionist, unquote. But as CBP officials have pointed out, the goal is not to end the trade. I'm talking not about state-imposed forced labor now, but talking about general Section 307. The goal is to clean up the supply chains, not to end the trade. And then finally, there's also the argument that enforcement at CBP is lacking in due process for importers and lacking in legal process for importers. But I think that we should avoid the idea that an adversarial proceeding could be inserted into this process without undermining its effectiveness. So I will leave it at that, given the amount of time that we have, and we can come back to these issues.
レンさん、ありがとうございました。今回ですね、様々な、国で、こうしたですね、輸入規制というものがございますが、今回、レンさんにつきましては、アメリカの、事例について紹介いただきました。こちらの法律についても、まだまだ課題があるということで、今後日本で、こうした規制をですね、導入する際にどういった方法、どういったような規制がいいのかというところ、今後も議論を深めていきたい観点かなというふうに思います。最後にですね、日本と、そして日本企業に対しての、提言をですね、ヒューマンライツのレポートで、書いておりますので、そちらについても少し紹介をしたいと思います。ケイドさん、お願いします。
Okay, hello everyone. I'm back. I'm going to talk about the recommendations from our report and some related points in this part. The first recommendation, as you can imagine, is for Japan's Diet to pass a new law banning the importation of products of forced labor and to use US Section 307 as a model. To add a point from Dean's talk, the Diet should take the good parts. They have the opportunity to improve the parts that need fixing from a labor rights perspective. One of the most important issues, or one of the important issues for adopting such a law in Japan from our own research, is related to the training and capacity of Japan's Custom and Tariff Bureau, or CTB, which should be administering this law. If the law is going to work, CTB is going to need new staff, which is trained in labor rights investigations overseas, and even reforms as simple as they should recruit staff that know the languages of the workers facing the violations and of the countries where they occur. We also recommended that experts from U.S. Customs Office visit with CTB officials to teach them best practices and help to build capacity. Not only the US, there's European countries, Mexico and Canada should have a law like this. So there should be communication between all of these offices to mutually build capacity and best practices. CTB should also open lines of dialogue with labor rights NGOs and experts, the people working directly with the workers, since they're often the ones that know the most about the violations better than anyone. One related recommendation we wanted to make was that, not explicitly said in our report, but which we have discussed a lot more since its release, is that any action taken under import ban law should always be worker-centered and always focused on improving the conditions for workers. So it's not only about preventing the indicators of forced labor or that products of forced labor enter Japan only. It should also have an eye on actually ensuring the conditions of workers actually improve and that they actually receive remedies for the violations, as well as that forced labor is ended not just for this one case, but across the board. This can occur when workers and worker groups are also part of the stakeholder dialogue with customs officials. There are a few other institutional issues that we recommended that should be addressed. The CTB agency should be sufficiently funded and equipped to conduct good investigations of forced labor allegations. Currently, the responsibility for business and human rights, or BHR, in the government is fragmented between multiple agencies. For example, the Ministry of Economy, Trade and Industry, METI, and the Ministry of Foreign Affairs, MOFA, which often leads to a lack of guidance from the government on how companies and possibly the CTB in the future should address forced labor cases. So there's fragmentation. We also recommended that the government create some mechanism to coordinate BHR among all the ministries, including the CTB. So from Dean's talk, you might have heard he mentioned the US has an interagency task force for this kind of coordination. This is something Japan should have too. But in particular, we recommend that Japan create a national human rights institution based on the Paris Principles, which is also a natural place to be the central responsible office for BHR action by the government. We also make some recommendations that go beyond the import ban law. We recommend that Japan's government also pass new laws requiring companies to conduct human rights due diligence among their suppliers and to disclose the results, as well as to disclose their suppliers, and also that they establish a human rights policy and grievance mechanism for suppliers. We recommend that Japan follow the recommendations of the UN Working Group on Business and Human Rights, which officially visited Japan last year and wrote a report on their findings. And we recommend that Japan revise its National Action Plan on Business and Human Rights with several reforms, including conducting a gap analysis between Japan's law and international rights and labor standards. We also gave some recommendations on Malaysia, which covered a lot of the issues that that was in part 2 of our report. I didn't have time to talk about that. And in the interest of time now, and also to let my translators know that I'm going to skip over the Malaysia part and go to because we didn't talk about Malaysia specifically, and go to the recommendations we gave to Shimano, 2 paragraphs down. Finally, we also give some recommendations to Shimano to address the continuing problems I mentioned before, including to provide full compensation for all of the costs and for all former workers that face the labor rights violations, not only the ones that complained in the recent case. We also recommended that they pass a series of reforms, including improved human rights due diligence standards, disclosing lists of their suppliers down to the source, informing workers about grievance mechanisms, and proactively engaging in stakeholder dialogue, not just in response to specific cases. This isn't just for Shimano, this is for all cases, for all businesses too. And I already mentioned in my previous part that we can be positive about an import ban law in Japan being effective because of the relatively significant market power and relatively high institutional capacity in Japan. Also, customs officials can look at how other jurisdictions like the US, Canada, Mexico, as well as some EU countries have implemented their similar laws and adopt best practices. We also think it's important that a major economy in Asia adopt this legislation to send the message that this is not only a Western concern, and violating companies shouldn't feel confident that they can simply move their supply chain business with other developed economies to avoid sanctions in light of the North American and EU import ban. Sometimes this goes under the heading of no safe harbor. Japan's a very important jurisdiction to, close off any safe harbors. The US and EU passing this legislation has already sent shockwaves in the region, but Japan passing it would probably shake up the region enough to see real reforms passed, considering how important a trade partner Japan is in the East and Southeast Asia regions. There are also good reasons for Japan to pass an import ban law. To begin with, Japan companies sell to markets in North America and Europe. As we've heard before, they'll also need to address forced labor violations to meet their standards. It makes sense for Japan to harmonize its laws with North America and Europe so that Japanese companies aren't punished at home for following international standards or the standards in these other countries. This is called the level playing field argument. It's one reason that large companies and business commentators in Japan are already starting to talk about the business logic of this kind of law. It's worth pointing out, though, that this argument works best with the large international companies. It's still a challenge to make, to get smaller companies on board, but that was also talked about in the previous session. But and the other reason is there's also growing public awareness that's beginning to build momentum for this kind of legislation. It turns out people don't want to enjoy products created by human suffering when they become aware of it. And the public is becoming a lot more aware of environmental and human rights impacts of the products they buy. I could address some potential concerns that business and critics have, but I think that was covered in the last section, and I can answer some in the Q&A section as well. So the main point we'd like to make for this entire webinar is that Japan has a real influence in the region to address labor rights violations in supply chains, and we'd like to see it live up to that potential. And we think that especially with the other G8 countries that are passing and starting to enforce this legislation, the momentum is beginning to turn in Japan in this direction as well. And I'll leave it with that on this optimistic note. Thank you.
ケイドさん、ありがとうございます。こちらのですね、提言は、私たちのレポートの第4章で、記載しておりますので、ぜひ全文を読みたい方は、ご参照ください。では、残り20分間は、Q&A セッションになりますので、まず登壇者の皆様はカメラをオンにしてください。ケイドさん、アンディさん、お願いします。すでに質問いただいておりますので、そこから紹介したいと思いますが、追加の質問の方、Q&A セッション、Q&A ボックスがございますので、そちらから、ご質問をお寄せください。最初の質問は、日本語で言った方がいいですよね。Has been any movement from the Japanese government toward legislating an import ban for goods produced with forced labor というご質問が来ております。こちら、ちょっと英語で答えますが、So back in 2023, in January, the Japanese government and the US government made a task force to fight against the product made with forced labor. So I think this is the one big the movement initiated by the Japanese government. The task force had one meeting, but that was in like a year or a year and a half ago. And after that, we don't see any movement. So we don't know what happened to this task force or any other movement from the government. So I think that's all we've got from the government at the moment. はい。それでは、2つ目の。Yes.
It's just worth noting, people are, anyway, there's a lot of talk about what will happen with the Trump administration that's coming, most of it bad from a human rights perspective. But one, I don't know if I should call it a silver lining, but it is coming with a strong agenda about using trade restrictions. And we might use this opportunity to use this shift in environment in the US to push for labor rights, import restrictions for labor rights. So we were thinking this is one thing that might revive this task force. We can use this task force as part of that, environment. So that's a reason to think that it might become revived in the near future. We hope.
ありがとうございます。ディーンさんへのご質問です。The question for Dean, so there is a U.S. uses prison labor, and the question is asking, shouldn't the U.S. confront its own enormous prison labor, often privatized to generate profit, and system of using prisons within the labor force? Do you have an answer for that?
Thank you. First of all, absolutely, the United States should address this problem. And Corporate Accountability Lab issued an extensive report about this issue over a year ago. And the legal issues are a little bit different because our forced labor in supply chain law is focused on imports coming into the United States, and it's enforced by the Border Authority, U.S. Customs and Border Protection. So there are different legal rules regarding domestic activity, but nevertheless, it is definitely something that the United States should address. And by the way, also, if the United States is exporting goods to other countries that are tainted by forced labor in any way, those other countries can employ their own import restrictions to prevent the tainted goods from coming into commerce in their country. So I think it's got to be a combination of approaches, but it could include litigation in the United States.
ありがとうございます。今お話しいただいたようにですね、レポートでも、まずは、その工場のあるマレーシアでの規制がないというか、機能していないこと、そして、まずはですね、その労働者を雇っている企業においてもきちんと労働者のですね、人権を守るということ、そしてさらに輸出した先の、国のですね、規制がない、段階がありますので、そうした段階すべてにおいて、是正を進めていくということが大切で、そのうちの一つの方法としてが、輸入国の、輸入規制というふうに、考えられると思いますので、リンさんがおっしゃった、いろいろなアクターがですね、それぞれで、強制労働を是正するための、システムを整えていくということが、必要となってきていると思います。はい。Then you have another question. Would you like to answer this one as well? The question says, does Dean Pinkert have an indication on whether the incoming U.S. administration is likely to amend Section 307?
I don't have an indication about this. I have some beliefs about it, which revolve around precisely the kinds of points that Cade was making just a few minutes ago. The incoming administration has some cabinet officials who've been very involved in forced labor issues and forced labor prevention activities and laws. And in addition, the original Trump administration, the first Trump administration, did take action to try to improve some of the legal mechanisms around forced labor, including the USMCA agreement, which is the U.S. Canada Mexico agreement that included a forced labor ban that is enforceable. In theory, it should be enforceable in all three countries to the agreement. So I think that if you add in the rapid response mechanism for labor abuses that was included in the USMCA agreement, I think that we see a pattern that can be exploited, not in the bad sense of exploited, but can be useful going forward to try to address some of these abuses. I'm not suggesting, and I don't think Cade would suggest, that it's all going to be the kind of aggressive approach that we would like. But I think there are some possibilities that we can push on to make it happen.
ありがとうございます。何かコメント追加がある方はいらっしゃいますか？ケイドさん、池さん。
Yes, I'm happy to jump in if that's okay, Angie. I'm really sorry. I've only really just noticed Andy put some commentary in the chat around the Global Slavery Index. I think that that's really useful feedback, and it is, I think, an indication of companies beginning to use the Global Slavery Index more and more, and maybe it being seen as a fairly blunt tool in terms of use in risk assessment. And it's certainly not the first time that we have heard this kind of feedback around, where we're seeing maybe low prevalence in countries, then companies might be taking that to mean it's also low risk. So I just really encourage any companies that are using tools like the Global Slavery Index or other tools out there to just take a risk-based approach and look at all the vulnerability factors that I spoke to before. Migrant workers obviously are incredibly vulnerable, and where you're sourcing from a place that really does use a lot of migrant workers, absolutely that is automatically going to increase your risk profile, and that needs to be taken into account. I just also add this is something that is a key consideration for us, and we will be looking at in the next Global Slavery Index. So while we're unlikely to change the methodology very much, mainly because we want the two indexes to be comparable, we probably will be putting a lot more commentary around the way that this can be used, and maybe what businesses and governments can be looking at. So essentially, while the ranking for the countries, so Andy mentioned, I think, Taiwan, Singapore, and Japan, for example, it's quite low when looking just at prevalence. He's absolutely right to say that there is a huge amount of risk, particularly when it comes to migrant workers. I would also add China, frankly, to that risk, where when you look at the Global Slavery Index, for example, we do have a whole section on state-imposed forced labour in Xinjiang, but we have absolutely had feedback from companies to say, well, if I'm not sourcing from Xinjiang, then China looks pretty safe. Absolutely, you need to look at the supply chains that you're operating in and where the risk lies there, and also aside from looking at migrant workers, also take a sectoral-based approach because, for example, I mentioned solar panels, electronics, garments, very, very high-risk areas, probably in all countries, but particularly those that Andy mentioned, and also China. Thanks.
Thank you, Cass. ありがとうございます。コメントへの、回答ということでお話しいただきました。で、one more question for you, Catherine. Are you able to explain a little bit more about labor conditions that were improved as a result of WRO in Malaysian labor law, and the issues that remain unresolved for workers in those factories if it has now been lifted?
I'm going to be absolutely honest. I think that would be a great question for Andy to answer because he was so closely involved, I think, in that remediation process. I don't know if Andy is still on the line.
Andy, are you here?
Yeah, sure. I can answer that. No problem. Yeah. Sorry, I just on the move actually. Actually, the WRO, the campaign on Malaysian rubber gloves, it was 2 stages really. Actually, we did a 1 stage where we managed to expose the systemic forced labor and the failure of the audit systems to detect that forced labor. So we did that starting from 2018. And we managed to bring quite a lot of changes to the industry, like they gave workers back their passports, they improved accommodation, they got rid of the deductions and things like that. But the workers were still in a lot of debt because they paid up to $5,000 or $6,000 for their jobs, And what we couldn't do with the companies, we couldn't get them to remediate the recruitment fees because they felt like it was just too much money. And of course, the buyers were never, contributing. But once the WRO came into force, it really led to this massive repayment of recruitment fees, and we estimate it's about $150 million that was paid back to workers in the Malaysian gloves industry as a result of our campaign and the WROs that we imposed against 6 companies. And it was really dramatic, and it led to a massive shift in the industry, whereby the industry never had an interest in social compliance before. It's really improved a lot. And I think that definitely there's still some challenges, but I think because of those WROs and because of the impact they had on the industry, it was it was in the middle of the pandemic, and that's one thing we need to bear in mind is that even though the WROs were imposed in the middle of the pandemic on 6 gloves companies, they could still export their products to other countries, and everyone needed gloves. So it's not like the companies actually lost a lot of money. They lost because the US has a high buying price. They didn't lose a lot of money. They just had to sell to other customers who paid less because they didn't care so much about the forced labor issue. But the industry really changed. But I think also what we have to see is that within the smaller companies, the SMEs, and lower down the supply chain, like the products, so the latex, where the gloves are coming from, the boxes, the packaging, we still haven't seen a lot of changes. There's still systemic forced labor in those industries. And within the smaller companies, there's still problems. But yes, I mean, the WROs, working alongside myself and the media and investors, they had a really dramatic change. And I think whenever I speak to CPB, I always stress to them how they really changed the conditions in the Malaysian gloves industry for the better. Because without them, these workers wouldn't have got the repayment. So.
Can I add something to that? So just not speaking about this particular case, but the Malaysian government did pass a bevy of reforms in the wake of this WRO. So I mentioned in my talk that the Shimano case is one example where you see the limits of that. But part 2 of our report goes into a very deep detail about how the law and the environment in Malaysia is still working. So read that if you want more details. But 3 things we noticed. Although they have these new laws, they need resources, standardized guidelines and procedures, but especially at the rural levels, because they're not being enforced, especially in the rural levels. And there's no guidelines or standardized practice in the country for these new laws. We recommended that Malaysia still needs to pass some core human rights and labor rights treaties, and particularly the core conventions of the International Labor Organization. And the biggest thing is that migrants are still vulnerable to retribution and all kinds of vulnerability when they make complaints and when they're put in this post-complaint period before there's some action. They're in a very vulnerable position, and that really hasn't been addressed yet. And also, Malaysia needs to start enforcing measures to prevent exploitative recruitment, which is at the foundation of everything. So those are things that Malaysia still needs to work on. That's all.
ありがとうございます。ご質問がですね。So we have one question, but so if anyone wants to talk about prison labor in the US, maybe this is not really relevant to this webinar, then we can skip that. Yeah. Okay. So we have あと残り3分になりますので、最後に、登壇者の皆様から一言ずついただければと思います。強制労働によるですね、強制労働を使って作られた、製品をですね、輸入規制という方法で、どのように是正するか、皆さんご自身の、国もですけど、もし何かその日本が今後、どのような、規制を進めて、どういったような期待があるかというところが、もしあれば、お話しいただけ、もちろんその他の、ウェビナーに関して全体的な最後のコメントでも構いませんので、一言ずついただければと思います。じゃあ、キャサリンさん。
Sure. Thank you. I think Japan is such a powerful economy that it can really make such a great change in the world. And I think it already is showing a great deal of leadership with its voluntary human rights due diligence guidelines. So we hope that these will be translated into hard law in the future, particularly as other countries begin to introduce due diligence legislation as well. I do think Japan has a prospect of being such a world leader here. And if it could introduce mandatory human rights due diligence legislation as well as a forced labor ban, I think it would make such an amazing difference to the lives of vulnerable workers worldwide who are impacted by Japanese supply chains. Thank you.
ありがとうございます。アンディさん、いかがでしょうか。
Yeah, I think for Japan, it's really important we look at both Japan as a country and the systemic abuse of migrant workers within the country, particularly the debt bondage from these high recruitment fees. It's a really terrible situation in Japan. And then secondly, we need to look at the Japanese companies and their activities overseas, which often involve low-cost migrant workers and systemic forced labor also. But I also think one of the challenges we face with Japan is that, for instance, it's on tier 1 of the US, trafficking report, So it's like, as I said, like Taiwan, also like Singapore, there's a lot of politics involved. And so, other countries are not really that serious to challenge Japan and the Japan government and the Japan companies to improve the situation. So it can be quite difficult. But, I think that's where I think Japan's own internal commitment this issue is important, because I don't think we're going to see global pressure on Japan to address the systemic forced labor issues within the country for migrant workers and within their supply chain overseas. It's internally from Japanese companies and their sense of morality, which I think is strong in Japan. They tend to ignore the bad things, but if you focus on the sense of morality, I think that's how we can move forward.
ありがとうございます。ディーンさん、お願いします。
So I just want to reiterate something that I started with in my remarks, that I am not here to tell anybody that the U.S. laws are perfect, that the U.S. practices on prison labor and other forms of labor are perfect. We have issues at the state level and at the federal level that need to be worked on. But at the same time, I don't think the right approach is to say, okay, the United States should stop enforcing its forced labor ban. I think we need to improve the forced labor ban, and we need to improve domestic conditions in the United States as well. And the one does not preclude the other. We can do both. And what I would like to see for Japan, but not just Japan, all of the countries in the trading system, is that there be competition to make more effective laws and more effective import prohibitions and more effective due diligence requirements, so that we're all incentivized to improve in this area. And it's not just a question of the United States doing it or another country doing it. We should all be doing it.
ありがとうございます。ケイドさん、最後いかがでしょうか。
Okay. So one thing I've noticed working in this area is how much feedback we've been getting from activists from the US and from the EU that also care about Japan. It's not only us. One reason also is because the laws in the US and EU aren't as effective if trade can transfer to Japan to fill that vacuum. So that was really interesting to me to see that, countries outside Japan also care very much about Japan also passing this legislation. And I think people underestimate Japan's influence in the East and Southeast Asia region. There's a large amount of development aid that's gone to these countries in Southeast Asia for a very long time. Japan companies are by far the largest source of, and well, also China, of foreign investment, but Japan's the one you can expect this kind of legislation. So that has a great amount of influence on businesses and governments. It's one of the largest markets in East Asia region, invested in Southeast Asia, that has the potential for this kind of legislation. And if you think in like a global perspective, it's like the entire, Eastern hemisphere. You need a large economy that starts with this to kind of set the foundation. Just for reasons of streams and economies of scale, Japan has such a critical and central role to play. So that's what I like to remind people. Thank you,
あり
everyone.
がとうございます。最後に私からもですが、今、ディーンさん、また、皆さんがですね、メッセージでしてくれたように、グローバルなイシューですので、こちらもいろいろなアクターがですね、協力し合っていかなければならないというところがあります。で、私たちは、ヒューマンライツナウとしてですね、コアリション、グローバルコアリションagainst forced labor in trade という、コアリションに参加しておりまして、このコアリションの、目標というところはですね、ノーセーフハーバーということで、世界中に強制労働の、産品が、輸入できる、セーフハーバー、そうした強制労働産品にとっての安全な、 港がないというようなところを作るというのを目的とした、コアリションで活動をしております。ということでですね、この、強制労働ある国、ない国ありますけれども、様々な負担への働きかけを通じて、そして特に私たちとしては日本政府、日本への働きかけを通じて、日本のハーバーをですね、政府じゃない、状態にしていくということで、これからもアドボカシー、そしてレポートなど、発表してまいりますので、また今後もですね、活動の方、ご支援いただければなと思います。はい。では、本日はですね、ちょっと日本時間だと、変な時間になってしまったことはあるんですけれども、ご参加いただきましてありがとうございました。最後にお知らせとなります。本日のアンケート、サーベイが、ありますので、こちら、ぜひご協力ください。こちらは日本語、英語、両方で、ご記入いただけます。で、ちょっと日本語の、参加者の方だけになってしまいますが、今後のヒューマンライツナウの、イベントの予定についても、こちらに、来週10日とですね、また再来週19日ございますので、ぜひまたご参加いただければと思います。本日はご参加いただきまして、本当にありがとうございました。